My name is Paul Chadwick, and I'm honored to serve as the chairman of Mena Melchizedek. I would like to kick off our session this afternoon with a prayer that we say at the onset of all of our meetings. In the name of the Father, and the Son, and the Holy Spirit, amen. O Holy Mary, Mother of Priest, who with your beloved spouse, St. Joseph, during your sojourn here below, did nurture, protect, and provide for the most sacred divine infant, Jesus Christ the High Priest. In remembrance of the joys, the sorrows, the sacrifice, and the sufferings you endured as the Holy Family, we beg you now for your heavenly maternal care for our beloved priest, your priest sons, O merciful Mother, both living and deceased. With great confidence, we beseech you to assist especially those priests who are the most troubled, tempted, discouraged, and suffering. Intercede too for us, O Holy Mother, that we should not forget how our father Abraham reverenced Melchizedek, king of Salem and priest of God Most High, even giving to him a tenth of all he had. With Abraham as our example, let us give constant thanks to God for all the good he has done for us through the hands of our dear priest. And let us never grow weary of giving assistance to all priests in their time of need. For as sung in the Psalms, God has sworn, and he shall not repent. You are a priest forever in the line of Melchizedek. In the name of the Father, and the Son, and the Holy Spirit. Amen.
Amen.
Thank you for joining us today. We at MOM greatly appreciate our priests, deacons, and bishops for all you do for our mother church. We are also grateful for your concerns on the issues detailed in our model policy, as evident by the large number of you who have taken time to join us this afternoon. So as a recap, here's how we arrived where we are today. In the summer of 2021, Mena Melchizedek received a request from a religious order asking if MOM would consider developing a model policy in dealing fairly with accusations of sexual abuse against their brothers while respecting the alleged victim's claim. The concerns of many priests center around a troubling lack of clear due process for accused priests, as well as a lack of clear guidelines for communication with the accused. It is a problem that virtually every single priest, active or accused, seeking assistance from MOM, asks, what is the process? As a result of this request, MOM's board of directors deliberated at length until it was decided to form an experienced group of attorneys to develop a model policy. 3 attorneys who have personally assisted accused priests, dioceses, and religious orders were members of the group of 4 laymen who worked on the policy. They drew on their various areas of expertise in criminal law, insurance law, civil litigation, and canon law. MOM's president, Joe Maher, drawing on over 20 years of experience in helping thousands of accused priests, was the 4th layman to participate in the drafting of the policy. The draft policy was then sent out for review by legal professionals and clergy, including a prominent civil attorney representing victims of clerical sexual abuse. The completed MOM model policy was then mailed to every bishop in the United States and is available on MOM's website. As a result, some dioceses have incorporated aspects of the MOM model policy in developing their own policy, others as additions or changes to their already existing policy. However, some dioceses desired an expansion of the duties and responsibilities of the Independent Review Board, IRB section of the model policy. So the MOM board of directors once again convened the same legal and professional team from the MOM model policy to develop this handbook in assisting bishops, religious superiors, and their IRB members in setting a just standard for the important work of the Independent Review Board. Given the sensitive and confidential nature of the work of the IRB members, this handbook hopes to provide fair and comprehensive legal and spiritual guidelines to assist IRB members in advising the bishop on the proper care and treatment of his priests while respecting the rights of all parties involved, including alleged victims. It also aims to protect the IRB members from the potential legal liability and spiritual perils of the life-changing recommendations IRB members are called upon to make to the bishop or religious order superior. Finally, we dedicate this humble offering to Mary, Mother of Priests and Mirror of Justice. as a gift to her church and thanksgiving for all the good works of our priests, bishops, and IRB members. Thank you for your ministry. Without further ado, I would like to introduce to you a man who is the tip of the spear when it comes to serving troubled and distressed priests and bishops when they feel they have nowhere else to turn. Since 2002, he has facilitated assistance for thousands of Catholic priests accused of sexual abuse. It is with great pleasure I'd like to introduce to you our president and my friend, Mr. Joe Maher. Joe?
Thank you, Paul. Well, I want to thank everyone who's joining us today for this very important presentation. As Paul had mentioned, last year we sent out the mom model policy after a religious order had asked us if we would develop a policy that would be a model for handling and dealing with sexual abuse accusations against priests. Out of that came the request from a couple of dioceses, an archdiocese and a diocese, for an expansion of the role and the duties of the internal review board, the independent review boards. This kind of stunned us. This surprised us because the independent review boards have been around for a long time. As Paul said, I've been doing this since 2002. And it surprised us because of the requests that were made for training for review board members, for more information for review board members. And of course, we don't want to poke our nose where it's not needed, so we respond only to the needs that come from, in these particular cases, bishops from their dioceses and from review board members. So the three gentlemen that will be following me are all experts, attorneys, and they're the three that we talked about who really were the drafters of the mom model policy and worked very hard on this independent review board handbook for review board members. The reason why it's so important, there are several reasons. First and foremost, the Catholic Church is about evangelization and saving of souls. That's why we're here. And eternity, obviously, we should be living for eternity. The whole world is looking at us, especially in the United States. There's no doubt about that. Well, the Catholic Church, we're in the press constantly. So we want to make sure that what we're doing and what we're presenting to the world is first and foremost Christian. And that's what the basis of this whole handbook that we put together was about. Following the church's teaching, following what the canon, the Code of Canon Law mandates for review boards, and then some practical aspects about civil law and criminal law, liabilities, and of course, respecting the due process for priests, the rights of alleged victims, those that may have been hurt by clergy, helping and protecting the bishop, and also, above all, helping to facilitate the great need that review board members have in fulfilling their sacred trust and duty to the bishop, which can't be understated. Because as I've learned over 20 years now in thousands of priest cases, every bishop now lives by the mantra that you don't go against the review board. Well, what does that mean? Well, that means that when there's an accusation brought to the bishop or to the diocese, he turns it over to the review board, or he gives them the accusation, and it is their job to collect information, to evaluate information that's given to them by an investigator, by the bishop, and by interviews, either with witnesses or with the alleged victim, perhaps the accused priest. And they have to evaluate all these things. And then they come up with a determination that goes to the bishop, and where they advise him whether a formal canonical process moves forward against the priest. This is the equivalent, we would call it a criminal charge in the civil realm, but this is a canonical charge against the priest for a grave delict or a criminal act. Now, for the review board members that are involved in this, the majority of them are lay people like ourselves. So we don't have what we would call probably clerical presumptions. Okay, we are very excited about the whole concept of a review board and lay people being involved in it, because it's much like our jury system here in the United States. Can you imagine a jury at a criminal trial not receiving instructions from the judge on how they are to evaluate all that's going to be presented to them? Well, that's what we're dealing with here with the handbook. This is what we try to present with the handbook. And these three experts, these three legal experts, are going to map this out for all of the review board members and for us so that we have a better understanding. So I don't want to waste too much more time away from them because they've got a lot to cover. I do want to say this though. Everyone that I've talked to involved in this process, including review board members and the team here and canon lawyers and diocese, we're all on the same page. Everybody wants to see that no child is hurt. And for that matter, no vulnerable adult is hurt. We want to see that if there's an offender, that he gets the help he needs and that he's restored back into the community in his rightful place. We also want to make sure that the whole world can see how we are to respond as Christians, because our sole goal in the church is evangelization. There's a whole world out there that doesn't know Jesus, and they're looking at us. And we have the opportunity to show them how to act and give them the inspiration to come to the church. So I'll turn it back over to Paul now, and I thank you all again.
Thank you, Joe, and thank you for all the work that you do for Men Melchizedek. Our next speaker is Joe Rashad, who is a shareholder and a senior attorney with Butzell, a prestigious law firm in Troy, Michigan. Joe was honored by Michigan Super Lawyers as a top appellate lawyer in Detroit. He focuses on complex civil appeals, criminal appeals, and appeals involving the press and many other disciplines. We are very fortunate to have Joe as our corporate counsel, and Joe is going to be our next presenter. So here you go, Joe.
Thank you for that kind introduction, Paul, and good afternoon, ladies and gentlemen. Due process may be a familiar term that evokes notions of fairness, but if someone asked you to define it, could you? Since due process is at the heart of what we'll be talking about today, I'm going to help set the table for Mr. Schoenefeld and Mr. Mazza by spending the next few minutes answering the question, what is due process? Due process means putting in place adequate procedural safeguards to minimize the risk of making an erroneous decision. But how do we decide if the procedural safeguards we have are adequate? We ask four basic questions. How important is the decision to be made? We make decisions every day. Do you want fries with your Big Mac? Do you want regular or decaf coffee? But we also make very important decisions. Is this the woman I am to marry? Am I called to serve God's people as a priest? Second, once we've decided what the decision is and its importance, we ask how well existing procedures reduce the risk of error. We want to get things right. And we know from experience that there are things that tend to lead us toward and away from the truth. Now, the lower the stakes, the fewer the safeguards you need. But the higher the stakes, the more safeguards you need. Then we ask, are there other procedures that we could adopt that would help us further mitigate the risk of error, right? We can all appreciate wanting to learn from our past errors and to avoid repeating them. We then do a bit of a balancing test, and we ask whether it would be too burdensome on the decision maker to adopt those other procedures, given the importance of the decision they're being asked to make. Here again, the higher the stakes, the greater the consequences of getting it wrong, the more burden we should be willing to accept on our decision maker. So now let's take those questions and apply them in the context of independent review boards. First, what exactly are IRBs being asked to do? They're being asked to help their ordinary determine the veracity of allegations. And we often hear it put this way: is the accusation credible. As Mr. Mazza will describe more fully, the technical term is semblance of truth. And there's a temptation, I think, for folks to treat the word semblance as possible, as in, is it possible the accusation is true? And of course, if that's the standard, the better to err on the side of safety and recommend that the priest be taken out of ministry, at least on a temporary basis, pending further investigation. But semblance doesn't mean possible. It means appearance. Does the accusation have the appearance of truth? And how do we decide that? Well, a standard that we advocate is whether a reasonably cautious person would believe that the complained of act probably occurred and that the person accused probably performed the act. Now, this is intended as a skeptical standard. Why? Because under the law of the church, just as in secular law, an accused is presumed innocent. A reasonably cautious person applies that presumption of innocence when deciding whether there is enough evidence, or in canonical terms, enough indications to believe the act probably occurred and that the accused priest is probably the one who did it. Not possibly, probably. Second, is the decision important? It's fairly obvious, but as Mr. Schoenfeld and Mr. Mazza will discuss in more detail, a review board's recommendation can effectively end a priest's vocation. Now, as Joe mentioned earlier, we know that there are priests who have done awful things to children, and we have a duty to protect children from predators. At the same time, it would be to our great discredit as Catholics if we treated every priest with suspicion and reflexively believed every accusation. We know that there are false accusations. Some are driven by bad motives, be they money or tension or spite. Others may have more neutral motives, like misidentification or false memories. But whatever they are, we do know that they exist. So, while we must not dismiss accusations out of hand, we can't blindly accept them as true either. So, given the gravity of those potential harms, on the one hand, the harm to the priest and the faithful by unjustly removing the priest from ministry in the case of a false accusation, and on the other hand, the harm to the complainant and others of leaving a priest in ministry if it's a legitimate accusation, how well do our existing procedures reduce the risk of error in the truth-finding process? Let me share with you a recent experience I had in one diocese. I was retained by a religious order to investigate an accusation against a priest about alleged events that had supposedly occurred more than a decade earlier. The diocese in which the religious order priest was ministering conducted its own preliminary investigation separate from the religious order. The diocesan investigator interviewed the complainant by telephone and exchanged a few emails after receiving an anonymous letter. She never met with the complainant in person. She confirmed that the accused priest was assigned to the parish where the young man claims to have been a parishioner at the time. She interviewed the priest, who denied wrongdoing, and reviewed his personnel files, which contained complaints about homilies and bulletin articles, conditions that were placed on the use of the parish hall, that type of thing. That was it. Based on an uncorroborated, unsubstantiated, faceless complaint, the investigator prepared a 3-page report and recommended that the priest be removed from ministry. The IRB agreed, and the priest was suspended. When I challenged the quality of the investigation and the decision, which I'll get to in a moment, the response was quite surprising. It was essentially, do you have any idea what the reaction would be in the press if we were to have left him in ministry? That's not a particularly Catholic view. It's a worldly one. We shouldn't, frankly, be concerned about what the press will think of our decisions. We're here and need to be concerned with how God is going to judge our decisions. And we are striving for justice, not good PR. So we then asked the third question: are there any additional procedures that could be implemented? Well, let's start here with requiring more thorough investigations. And let me briefly contrast the diocesan investigator's approach with my own. I extracted from the complainant's letter and emails objectively verifiable facts. Now, obviously, we don't want to get too far into the weeds so that we can maintain appropriate privileges, but I'll give 3 examples that are generic enough that they could apply in a very wide range of cases. First, the complainant claimed this happened for 6 to 12 months when he was 9 or 10 years old, and it stopped when his brother started serving with him at altar. So what did I do? I pulled his baptismal certificate to determine when he was born. And I compared that to the ages that he cited in his letter to determine the years on the calendar when the abuse allegedly happened. I then pulled the priest's record of assignments to see when he was assigned to the parish. Turns out he was first assigned in October of the year when the complainant was 10. I pulled altar server records. This was a decade earlier, so the records were incomplete, but it turned out the complainant's brother was scheduled to serve midnight mass the year the priest was assigned. As a general proposition, brand new altar servers don't serve midnight mass. Experienced ones do. So I found it doubtful that this was the younger brother's first mass. But keeping an open mind, because this was an investigation, I assumed that it was. That would mean that the window of the alleged abuse could only have been the first 3 months after the priest was assigned to the parish, not for a 6 to 12-month period of time. Second, the young man also described the room in detail, down to a floor-to-ceiling sliding door that had a curtain over it. Unlike the diocesan investigator, I did a site visit. I went to the church. I went to the room where this was alleged to have happened. No floor-to-ceiling sliding door window. No curtains. There was a steel emergency door and a standard size window on the wall next to it. Now, again, we got to go a little bit further. So what did I do? I pulled the architectural plans to see if any remodeling had been done. The space had been added only a few years before the priest was assigned to the parish, and the plans showed an emergency door and a standard window. So there had never been a sliding glass door, floor to ceiling with curtains there. Third, he claimed the act in question happened every Sunday in the room where it was just off of the sacristy. And he was told to arrive 15 minutes before the other altar boys for the 8 o'clock Sunday mass. And he claimed that this was on the schedule. Well, we had schedules. And it turns out none of the schedules ever indicated anyone being directed to arrive earlier than the other altar boys. But we didn't stop there. We found and we located the young men who were altar boys at the time. Each of them said they only had to arrive 15 minutes before mass. No one had ever been instructed to arrive earlier. But again, for investigative purposes, let's assume the accuracy of the allegation. It would mean that the complainant was supposed to have shown up at 7:30 in the morning. Who's at mass 30 minutes early? Custodians, maybe some office staff, and little old ladies praying the rosary. I tracked them down. I interviewed them. I found out that the priest had a routine from which he never varied. Every Sunday morning, he was in the confessional at 7 a.m. and he heard confessions until 7:50, at which time he went directly to the priest's vestry, which was on the opposite side of the altar from the boys' vestry. Where was this confessional? On the opposite end of the church from the sacristy, where the nave meets the narthex. I then interviewed the complainant in person. He told me the abuse didn't start until 6 months after the priest arrived at the parish. Without knowing it, he had just ruled out those 3 months when this could have conceptually have occurred after the priest arrived based on his own written description of the events and parish records. Nothing was lining up. So I explored possible motives. Through interviews of parishioners, I learned there was a vocal minority who disapproved of the priest, shunning a group with whom that minority was close, including the complainant's family, over some doctrinal differences. To be clear, we interviewed people on both sides of that divide. That's part of a thorough investigation. In reviewing the priest's personnel file, I found a series of escalating complaints from members of the vocal minority and ever more strident demands to transfer him to another parish. When he wasn't transferred, along comes this allegation. When I interviewed one of them, she even said to me, they can't bring him back now, can they? Now, that's just a high-level overview. I could spend a whole webinar going through it as a case study on how to conduct a thorough investigation. But it gives you a sense that there are a lot of additional investigative actions that could have been taken to reduce the risk of error from that initial diocesan investigation. And it shows the need to critically evaluate an investigator's findings to further reduce that risk of making a wrong decision. Now, I can tell I'm running a little over time here, and so as not to get the hook, I'll jump forward to the 10th man rule that you see here as the last bullet on the slide. Mr. Schoenfeld and Mr. Mazza are going to do a fine job covering the presumption of innocence and offering a canonist's perspective. The 10th man rule is a technique that's used to reduce the risk of snap judgments and groupthink. If consensus is reached quickly, one way or the other, a member of the group is selected to argue the contrary view and try to poke holes in the majority's reasoning. Now, it doesn't mean the majority will be swayed, but it does ensure that a real effort is made to critically evaluate the facts from the presumption of innocence. That brings us to the balancing test of due process. We've considered the importance of the decision, the adequacy of existing procedures, and how new procedures could further reduce the risk of error. Are those new procedures worth it? Is the cost or the burden to the church too great? As you see here, I have a couple of bullet points that talk about some of the policy considerations that would go into that balancing test analysis. They're not intended to be exhaustive. I'm sure, will have some additional ones that you could think of for or against those additional procedures. But I think we can all agree there will be longer investigations, and those longer investigations will result in delayed decisions. And the delay, of course, can cause some anger or frustration, not just at the complainant level, but also at the level of the priest, who may be frustrated that things aren't moving quickly enough. Of course, if there are delays, there may be some bad press that comes along with that. And those are drawbacks, to be sure. But on balance, I think the rest of these more than make up for that. You do get better informed recommendations to the bishop or the superior. You get increased confidence in the fairness of the process for all involved. And for that, I want to be clear, it's not just the complainant, it's not just the priest, but also for the parishioners. These are folks that are going to have a priest removed from ministry from their parish, a priest who may very well be beloved and throw the parish into a bit of chaos. But if they can appreciate that there was, in fact, a thorough investigation and that everyone was given a fair shake, then that increases their confidence in the fairness of the process and overall promotes respect for the rule of law throughout the church. So ultimately, as you're looking at this balancing test and making a decision of what additional procedures and safeguards we should adopt and whether they're worth them, I offer these last three questions here for your consideration. Do we owe it to the victims of abuse to get this right? Do we owe it to our parishioners to get this right? And do we owe it to our priests to get this right? Yes, without a doubt, to all three of them. So with that, I want to thank everyone for the opportunity to present on the topic of due process. I hope it was helpful. And Paul, I will turn it back over to you for our next speaker.
Thanks, Joe, and thanks for a very fine, well thought out presentation. I would just like to mention there are some people who have already pinged us with some questions, which you can do. And even though we slated it for an hour, we know we'll probably run longer, and we will have a Q&A session afterwards. So, but please do, if you have any questions, feel free to shoot them our way, and then we'll make sure we cover them at the end of the session today. Our next speaker is also a board member of Men Melchizedek and a good friend, David Schoenfeld. Dave is an attorney with the Alvarez firm in Calabasas, California, where he represents insurance policyholders in disputes against insurance companies. He's a former trial attorney with the U.S. Department of Justice in Washington, D.C., with more than 30 years of experience in litigating complex civil matters in state and federal courts across the country. And with that said, I will now turn it over to Mr. Schiefeld.
Sorry. Thank you very much, Paul. And thank all of you for joining onto this. It's a packed program with more than we could possibly handle. We thought about multiplying this in different ways, but ultimately we want to focus on the issues that are at stake with the IRBs. And one of the things I want to take a deep dive into are the fundamental human and canonical rights that are at stake here. Sometimes we forget what those are, and it's nice to reflect on that and see what's required under canon law and basic human rights law as well too. So I'm going to go through a lot of slides here. Keep your seatbelts on, but it's important to step back and look at the entire backdrop here. What's at stake? Well, this side of the Garden of Eden, we've got conflicts of interest, and they're genuine conflicts of interest. On the one hand, you've got victims' claims, and they need to be adjudicated, and then you have the wrongly accused that is, defense against those claims. And so the victims' claims are presented in such a way that they need to be investigated, they need to be evaluated, and they need to be addressed. And by the same token, the wrongly accused has needs to protect against those claims, to defend against them, and to be absolved in case they're innocent. We are immersed in this, though, against a backdrop of extraordinarily explosive factors that are involved when charges are made and heard under a vast historical record of past sexual abuse, suppression of reports, distrust of complaints, reluctance to apply canon law, insensitivity to victims, adverse publicity, hostile media, hostile advocacy groups, and then, truth be told, protection of privileged ecclesiastics over time. All of these factors weigh into this to make this an extremely difficult environment in which to adjudicate these conflicting interests that are involved. Well, what are the authorities that guide us? Well, there are really four, and I'm sure you've probably heard of all these or most of them. First is the Dallas Charter, which came out in 2002. The United States Conference of Catholic Bishops had put this together to give principles and guidance on what to do in relation to charges of abuse. It's been amended 3 times since then. We have the essential norms that also exist. This is, church law, as it were, that explain what, how boards are required to operate and how to deal with allegations of abuse. We also have the motu proprio that Pope Francis has published and reissued again just recently, this past March. These also involve procedures for the preliminary investigation of allegations of sexual abuse of minors and other vulnerable persons. Now, along with that is probably the most frequently cited and addressed document. It's called the Vademecum. And this is another Vatican document that addresses points of procedure in cases of sexual abuse of minors. It doesn't, speak to the vulnerable persons or others, and obviously it'd be hugely helpful in dealing with those kinds of cases. But it's something that is of effective guide in instructing how IRBs should operate. Now, again, considering the backdrop here, what does the church commit to? Well, in all fairness, and irrespective of what anybody says, that the church is deeply committed to several things. Number one, to treat all of the allegations seriously, to respect the rights of all the who are involved, to extend ministry to victims, to hold clergy adjudicated guilty as responsible, to exonerate clergy who are adjudicated innocent, to educate people about the problem, to educate people about false charges, to perfect screening procedures for candidates, and of course, to cooperate with law enforcement as well. Now, back to this Vademecum. I love this because it's a nice Latin word that means what it says. It means go with me. It's a handbook or guide that is to be kept constantly at hand for consultation. And if you think about it like this is something that, again, part of the backdrop important to consider. But under civil law, the goal is to protect the civil common good. But under canon law, it's different. It's to aim to protect the ecclesial common good and the salvation of souls. And the purpose then is, broader and different than civil law is. The purpose is to restore justice, to repair scandal, and to reform the offender. These are all the goals of this, and the Vatican wants to make sure that in applying church law that these purposes are observed. Now, fascinating to think about this is if you step back for a minute and ask about, well, all these charges ultimately involve canonical penal law, don't they? Well, yes and no. No punishment is appropriate under canonical law unless two things happen. You have to have an external provable violation of law that's occurred, and it has to be gravely imputable to the actor. All right, so far so good. You probably say, I get that. I understand what penal law is. But what about a preliminary hearing? So preliminary hearing, a preliminary investigation is not part of the formal penal process. It's not. It's something very different. And it's supposed to operate like a grand jury, where the grand jury determines whether formal charges should be filed or not. The problem is that we hear, and you can hear from many of our members that deal with this, is that for all practical purposes, this preliminary hearing is really not preliminary. It ends up being final, because many accused anyhow, or at least to just give up after the preliminary finding. They say, well, the gig's up and I'm done. And at that point, something very serious happens, potentially. You have a loss of a religious vocation, and perhaps unfairly. Now, let's turn to some of these bedrock principles that undergird canon law. And the first one is this, is that the accused is presumed innocent, right? They're not presumed guilty. They're not presumed neutral. They're presumed innocent. I hesitate to mention this, but I hear even lawyers, even we lawyers, civil lawyers especially, forget these all the time. They think that the guy, because he's wearing an orange jumpsuit sitting behind a table, is presumed guilty because the cops wouldn't have arrested him otherwise. And a lot of people come in, the IRBs, thinking the same thing. Well, he must have done something, or a complainant would have said something. Well, I'll presume neutrality about it. That'd be a best case scenario, really, if they're going to make a false presumption. But it's not the right one. It's the wrong one. You have to presume they're innocent and start with that as a principle. Now, here's another interesting fundamental principle, that every human being under canon law has a natural right to privacy. The Latin is intimitatem, which is really kind of broader than privacy is, but it works on our tongue, so we can use it as well. And when you think of privacy in our modern context, it includes such things as private communications, phone calls, texts, emails, past private history, including one's sexual history. Hey, Father, we'd like to tell us about the first time you started watching pornography. Tell us about your masturbation history. What kind of fantasies have you had over time? I'm sorry, folks, but that invades somebody's natural right to privacy, and they're off limits. Their mental thoughts are. Their medical condition is. Good grief. We all know about HIPAA and how that operates. You can't do that in the workplace. So why would we be trying to violate that here? In short, though, whatever society or custom regards as private is going to be regarded as private, and canon law is going to recognize that as something that's private. Another fundamental right, a right to a good name. Every human being has it. And, we think of at least one context in which that occurs, which is slander. And that's utterance of false charges or misrepresentations, which defame or damage somebody. But there's another one too. It's called detraction. In fact, the church calls it a mortal sin, objectively speaking. And that's the sin of revealing another person's actual faults to a third person without a valid reason. If you don't have a good reason to do that, you shouldn't be talking about it. And the reason is fundamental, is that the harm to that person is deep, it's lasting, it's difficult to heal, and it just strikes at the core of one's persons and soul. Now, another fundamental principle, strict confidentiality. I get that. Most people get that. They understand it. But it's nice to be reminded about this, particularly when you see provisions in the Vatican. The canons speak of protecting the good name of persons involved, everybody involved, accused, victims, witnesses. so that the report won't lead to prejudice, retaliation, or discrimination. And the one who carries out the preliminary investigation, and I highlight this again, preliminary investigation, must therefore be particularly careful to take every possible precaution to this end, right? Because this is a right to a good name that each of the faithful have. It goes on. Great caution should be exercised in providing information about the facts. Statements should be brief and concise, as they say, since this is to be established only by an eventual penal process aimed at verifying the basis of the accusation, right? This is not full trial on the merits yet. This is preliminary, even though a lot of people don't think it is. And they, again, since the possible guilt of the accused has yet to be established, everything should be taken to avoid anything that could constitute an anticipation of judgment on the merits of the facts. Now, another potential surprise here under canon law. Did you know that no one can be required to take an oath? You cannot force someone to take an oath, ever. It's not allowed. Canon law prohibits it. It's equivalent, at least, to the Fifth Amendment right against self-incrimination, which says you can't force anybody to testify against herself, but it's probably even broader. The Fifth Amendment doesn't protect such things as non-testimonial compulsory evidence like handwriting, blood, urine, DNA, finger samples, but canon law might, because its protections of privacy are deeper and broader. There's no way that you can compulsory impose a polygraph or lie detector test. You can't make somebody sign sworn statements or declarations. You can't. You do it. You may be frustrated by that. You may think that it lends some credibility to guilt. Sorry, that's not something you can take into consideration when you have a burden of innocence, burden of proof that presumes innocence at stake. Now, what about this? This comes up a lot, that a lot of people think should be a fundamental right, and that's giving advance notice to the accused. In most cases, you get sued or you get hauled into court, you're given a document that says exactly what charges you're facing. The canon law isn't clear on that. It says there's no uniform criterion or explicit provision in law. What it says is that an assessment must be made of all the goods at stake. You have to protect the good name of the persons involved. You have a risk of compromising the preliminary investigation. You could potentially give scandal to the faithful. And there's also an advantage of trying to collect evidence in advance, to build your case, all of which presents interesting issues. But an issue that's lurking there is there a lack of due process because you're not giving advance notice to the accused? We recommend that you should, subject to very extreme exceptions, but our model policy, says if you're going to be accused of something, you should know what the accusation is. There is this in canon law, which I find, ambiguous. It says that it should be clearly explained to the party in question that the measure is not penal in nature, lest he think that he's already been convicted and punished from the start. Well, that presents an instant issue. If you go to Father Bob and say, hey, Father, we're just doing a preliminary investigation. We need to talk to you about some stuff. I got some questions for you. Would you mind? But remember, this is just preliminary only. It's not penal in nature. Well, Father Bob might decide to spill the beans when good Joe Rashad might, want to put duct tape over his mouth and say, no, you're stating that wrong. It's not that you're guilty, but you're giving them evidence that they could use against you that would lead to a false conclusion. Don't do that. Don't talk. Well, if you're telling somebody it's not penal in nature, is that misleading? Because if for all practical purposes, the preliminary hearing is dispositive, then one could be misled, arguably. How about the right to counsel? Criminal defendants get the Sixth Amendment right to appointment of an attorney. Canon law says that's not required. It says since this is a preliminary phase, it is not obligatory to name an official advocate for him. The accused can be assisted by an advocate of his choice, which is important to point out because sometimes they're strongly discouraged getting one. But you have critical issues of this so-called, notice that, by the way, you have a right to a counsel of your choice. Will the accused be advised of that right? Well, they should. What information will be given them? Well, it better be specific. And when will be given to him? Well, it should be pretty doggone early in the proceedings and not later before he's compromised himself. And how are you going to do that? By what means? You can do it by phone call? You can do it by email, a text or something? Well, no, we think it should be done by formal letter because it's a formal process and formal things are done, in writing. So again, if you don't do these things, do you have issues at stake about due process? Well, arguably so. What about this? Again, Constitution provides criminal defendants to a right to a speedy trial, right? Well, the Vatican says the same thing. Effectively, it says an unjustified delay in the preliminary investigation may constitute an act of negligence on the part of the church. Well, what's an unjustified delay? 6 months, 1 year, 2 years, 3 years? I don't know. These delays happen. Who determines whether it's unjustified delay? Who determines whether it's an act of negligence? Well, I think at some point, at least, the accused is going to have a right to appeal to the ordinary and say, excuse me, that this is just taking too long and it's violating my fundamental rights under canon law. I think that would be appropriate here, and that too would be a fundamental right. Assistance to the accused. Well, both the victim and the accused have equal rights. They have to be treated with dignity and respect. They're entitled to the welcome, attentive hearing, support, the church, spiritual help, medical, psychological help is needed. But it's important to note they both are. It's not just, yes. We have to provide that to the victims. But we also have to provide it for the accused as well, too. Now, here's something that Joe Rachat touched on. I'll tell you, there's an old joke says you put 2 lawyers in a room, you get 3 opinions. Well, we've got 3 or 4, of us sitting around here, and we have like 15 opinions. The IRB under canon law is supposed to make findings that have a semblance of truth, right? That's the goal of this whole process. If there is a semblance, then the complaint moves forward, supposedly, unless, for all practical purposes, people drop it because they don't want to fight it anymore. And if there's no semblance, then the matter is dropped. All right, let me ask you this. As Mr. Rachat did, and Michael Mazza explained too, what is a semblance of truth? Well, friends, good luck, because there's no guidance in American law that speaks to it. And believe me, as you probably know, American law is riddled with all kinds of standards of every kind. Semblance of truth is not one of them. And I'll tell you, if somebody after this presentation came to me and says, Dave, you know what, your presentation had a semblance of truth, I'm going to take that as an insult. So because I think, generally speaking, that involves a pretty low standard. So what a lot of review boards have done, and I sympathize with them, is since you have a term that's unknown in American law, what do? Well, you come up with terms that are used in American law, like credibility. What's credible? Well, here's the problem. It's not defined anywhere in any of these documents, the Dallas Charter, essential norms, the motu proprio, or the Vatican. And when you have a term that's not defined, what happens? It's not a terrible surprise. You're going to have definitions that vary greatly. You're going to have people who take the same definitions and apply them greatly. And at the end of the day, what is the risk that happens? Capital punishment of a vocation. That's a problem. We tried to wrestle that in our model policy. I just want to give you a sample definition, and I just want you to wrestle with it for just a second, because, again, careers and vocations are decided on the matter. Credibility says that the IDR has followed procedures and found that a reasonably cautious person would believe that the allegations probably occurred and the accuser is one who's performed it and a subsequent penal process is warranted. All right. You want to tell me then what a reasonably cautious person would do or would believe, or allegations that probably occurred? Nothing in here addresses something that is well known in the criminal context, which is probable cause or probability, something like that. Instead, people feel nicer by saying, well, why don't we just say credible? Well, okay, but what's credible? I mean, if you look at the burden of proof scale, starts at the bottom, you have some evidence, and goes all the way to top beyond a reasonable doubt. And that, dotted line in the middle is the 50% mark. So if you ever sat on a civil jury trial, the judge will say, hey, you have to decide based on the preponderance of the evidence. That means 51%. Okay, you just lean over that line, you got yourself a finding in a civil case. And beyond a reasonable doubt is a criminal, and that's higher. So where does credibility fit in? It seems to be, according to the standards we have, that it seems to be something that's probable cause, maybe more than probable cause, right up to the line. Does it go over the line? I don't know. There are some review boards that like living by a standard that says, well, we'll consider whether the allegations are substantiated. Okay, fine. What does that mean? Does that mean it's less than 50%, more than 50%? What do we say when we say that a complaint is substantiated? So when you say semblance of truth, I'm sorry, folks, but I'm going to take that as an insult if you tell me my presentation has a semblance of truth, because I'm going to think it's, somewhere below reasonable suspicion and above reasonable indication. Maybe not. I get that. But there's a lot of room there on this nice graph that moves up to that dotted line and possibly past it about who, at what time, under what circumstance, and what conditions, and what case, with what people involved, are going to be telling you that a semblance of truth exists for the accusations to make a finding against this particular cleric. So the consequences are huge. You got the lower the standard, the more likely a finding. You got a higher standard, the less likely a finding. All right, so, put that in the context of the issues here. If you have a practical finality of the preliminary proceeding where people just give up and say, glad we're done with that case, let's move on to the next one when it's preliminary, well, you've got some major issues to deal with. And, so does the defense too. Joe Rashad will tell you, as a good criminal defense lawyer, there are plenty of times he might want to put the accuser to the burden of proof and have his client say nothing and sit there and say, you haven't met your burden, so I'm not going to say anything like that. Well, if he knows, and then reserve the right to fight it at a true hearing down the road. Well, if there is no true hearing down the road, why would you take that strategy? How about this? We could have a whole seminar about this. What about all these lists that get published by dioceses around the country of, here's our list of those who've been credibly accused of misconduct? Really? I mean, when's the last time you've seen General Motors or Microsoft or Google publish lists of those, mid-level managers who've been accused of sexual harassment? Yeah, there's a reason why you don't find those published, even though they have been, quote, credibly accused. Like I say, we could take a whole seminar about that. But the bottom line here is there's a loss of a good name, very likely. So again, and depending on what standard you're using here, you've got serious problems about whether you're impinging on somebody's fundamental right to a good name. So let me close off with this. The canon law is clear. The bishop has the sole responsibility, and for the preliminary investigation too. And never, ever, ever forget that the review board is to assist and not supplant the ordinary. It's to assist, not supplant the ordinary. Let me say it again, it's to assist, not supplant the ordinary. That's exactly what this says. And unfortunately, there's this huge temptation. Oh, let's defer to the experts. Oh, I can't question people. I have a former FBI agent who sits on our board. I have a psychologist. I have a social worker. Yeah, right. I know you do. And maybe the deck has been stacked against somebody because of it. Listen, I deal with experts all the time in the civil law, and I don't have terribly high regard for them all. And ask any litigator the same thing, they'll tell you the same. So it doesn't do you any good to say, hey, sorry, I just relied on experts, because that just doesn't fly, at least in the civil context. Again, the ordinary has the ultimate discretionary authority, and he should not fear exercising it at any point in time. I close with this because I expected to see this somewhere appearing in any of the 4 principal documents at stake, or even in the Vademecum. I just think, and we all think, Minimum Melchizedek, that this is something you got to commit to prayer. I mean, these are hugely serious issues at stake, and they go right to the core of the church's mission. We've got salvation of souls involved, the protection of the priesthood, and we can't forget this. Civil courts might, we can't. And that's this, we contend not only against the flesh and blood, but against spiritual hosts of wickedness in the heavenly places. Do you think there are spiritual hosts of wickedness in the heavenly places and in the IRB context and the investigation, and with all the people involved that are trying to work wickedness? Sorry, if you don't think so, I disagree. I do think that exists, and it's something that we need to pray to protect against. With that, I'm going to turn it back over to Paul. If you have any questions at any point in time, please hunt any of us down for it. We'd be more than happy to talk you through the issue. Thanks very much. And Paul, back to you.
Thanks, Dave, for just a really content-rich presentation. I just want to remind everybody, we're really racking up a lot of questions we will get to. Batting cleanup, we're going to introduce Michael Mazza here in just a second. And also, just know that this whole session has been recorded and will be available to you, because there's so much content. I'm sure people are going to want to go back and review some things. So it will be available, I think, if I'm not mistaken, it'll be on our website. We're going to make it public that you guys can come back and view this. So next on our docket is I would like to introduce another very prominent attorney. His name is Michael Mazza. He was also one of the driving forces behind the model policy. Michael is a civil and canon lawyer who advocates on behalf of clerics, religious, and lay people. After graduating from the College of St. Thomas with a degree in theology, he earned a master's degree in religious studies and then changed career paths, obtaining a JD in 1999 from Marquette University Law School, where he served as editor-in-chief of the Law Review. Michael obtained a license in canon law from the Pontifical University of the Holy Cross in Rome, where he successfully defended his doctoral thesis in June of 2022 on the right of a cleric to his good name. He has lectured and written widely on today's topic, and we are happy to have him with us here today. Michael, the floor is yours.
Great. Thank you for that introduction, Paul. And welcome to all who are viewing this live and all who will view this later as well. I'm happy to lead you through the Mena Melchizedek Independent Review Board Member Handbook. And while I hope that everyone on the webinar finds what I'm about to share helpful, I'll be speaking directly to those of you who serve on review boards. So on your screen is the first part of the table of contents. And after some preliminary items, we deal with particular responsibilities and considerations for review board members, as well as what the law says should go into the makeup of an IRB. Then we move to pre-meeting considerations, points to consider during the meetings, the decision itself, and then what happens after the decision and the canonical process. There's also an FAQ section, which we might be able to get to if we have time at the end. So why are we doing this? It's simple: to provide a useful tool for the church in the task of accomplishing justice, to encourage consistency among dioceses and religious orders, and to help IRBs carry out their important work. It's essential to keep in mind that IRBs serve an important but very focused purpose under canon law. The norms provide that they act as a confidential, consultative body to the decision maker, which is to say the bishop or the religious superior. Strictly speaking, the focus of an IRB is limited to cases of a grave delict, and that's the canonical word for a crime. But the essential norms provide that they may also review suitability determinations as well. IRBs are not permitted to determine guilt at this very early stage of the canonical process. The standard articulated under Canon 1717 is whether the accusation has enough, quote, semblance of truth, quote, has been mentioned earlier, and the Latin for that is saltum veri similem, semblance of truth, to warrant a further canonical process. And we'll come back to that in a bit. So just a quick comment. Under canon law, assessing suitability for a particular office under Canon 149 is not the same thing as suitability for the exercise of ministry in general under Canon 1044. Both of these decisions are ultimately, of course, up to the bishop, and he can consult whomever he wishes in making such determinations in accord with the law. So in other words, the decision over who becomes the next pastor of the largest parish in the diocese is one thing. The decision to prohibit a priest from all public ministry whatsoever simply because he's been accused of some kind of wrongdoing would be a problem under the law. Priests can exercise certain priestly ministry by virtue of their ordination, unless certain faculties are removed in accord with the law. We'll talk about that in a second. In any event, an IRB's duty of confidentiality is tied to the good of souls. People speak a lot about the importance of being transparent, and sure, understood as appropriate access to necessary information, that's fine, and even a good and necessary thing. But transparency doesn't trump a person's natural human right to confidentiality and to protecting his good name, nor does it mean interpreting very narrowly the good of the people of God. I would imagine that most review boards have confidentiality agreements in place that reflect these goals. Now, liability may attach under either civil or criminal law, and so it's fair that the IRB members should have a right to inquire about liability coverage. And we should all keep in mind the warning about judging our neighbor in Matthew 7, where our Lord says, "The measure with which you measure will be measured out to you." According to the essential norms, a review board must be made up of at least 5 persons of outstanding integrity and good judgment in full communion with the church. Should also include an experienced pastor and an expert in the treatment of child sexual abuse. And a majority must be lay people who are not employed by the diocese. So we can't ignore that there are objections to the entire review board concept. Some people, both in and out of the church, claim that review boards are just echo chambers for the bishops, or the claim is that they are hopelessly conflicted, either by being too close to victims or too close to priests, too close to the bishops, or whomever. And some have asked whether the promoter of justice should sit in on the review board meetings. Well, if he's seen as just the prosecutor, that might be a problem. But if he's seen as the one who's making sure that justice is done and that all parties are being treated according to the law, then that might be a good thing. The essential norms state that it is desirable that the promoter of justice participate in the IRB meetings. Now, either way, Catholics have to remember that having a board totally outside of the influence of the bishop would not be consistent with the Catholic understanding of the role of a bishop, where by virtue of his office as vicar of Christ in that particular diocese, he is judge, lawgiver, and administrator, as well as pastor and shepherd and referee and father and brother and loads of other things. A review board totally outside or independent of the control of a bishop would be a problem. In one diocese, when I remembered the chancery staff and civil attorney about this, that they said that they were told by the state authorities they had to keep the review board independent of the bishop. And sadly, I'm not exaggerating. That's exactly what they said. Well, beyond the obvious First Amendment issues that were raised there are also canonical problems, because bishops are duty-bound to see to it that all ecclesiastical laws are observed, and the failure to do so can be grounds for canonical penalties, including removal from office. Now, canonical investigations are distinct from civil ones, and as Dave Schoenfeld was talking about, they must be performed promptly. Now, very often, dioceses and religious orders refuse to take any canonical action on an allegation until all risk of secular litigation, criminal or civil, is over, on the basis that they don't want to be accused of interfering with such proceedings. This argument may have some merit in special circumstances, but to remain inert as a general rule is problematic on the level of both theory and practice. On this score, it's interesting to point out that Vos Decis Lux Mundi generally provides 30 days in which to start an investigation against a bishop and 90 days to finish it. We have to remember that the civil and canonical realms have their own ends and means. While the state is supposed to protect the common good in a temporal sense, and they have recourse to coercive police power, the church is obligated to foster the salvation of souls. Simply abdicating that sacred obligation for what could be an extended period by refusing to take any action on an accusation betrays either vincible ignorance of this obligation or a lack of commitment to carrying it out. Civil corporations routinely have to navigate these waters when a complaint is made against one of their employees, when the nature of the complaint raises the possibility of criminal or civil liability. If secular businesses can figure that out, it's reasonable to expect the church to do so as well, especially when aided by competent lay people. And second, as a practical matter, an accused priest named in a lawsuit could wait for years before a matter is resolved, given the large amount of litigation in U.S. courts and legal developments such as extended statutes of limitation. Now, Pope Francis famously lamented in 2014 about the intolerable delays that many lay people experience when seeking a declaration of nullity. If a period of years is too long for lay persons to have to wait to receive a judicial determination of their marital status, it seems only fair to expect a prompt determination of priest disciplinary cases as well. It's simply unconscionable to expect priests to wait for long and indeterminate periods before taking any action whatsoever on their matter. Canon law provides that Christ's faithful have the right to lawfully vindicate and defend their rights before the competent ecclesiastical forum in accordance with the law. It's Canon 221. Excessive delays either mean that that right is simply an empty formula, or it means that the church does not have a functioning system of justice. There's no alternative, in my view. In any event, another pre-meeting consideration is that IRBs must scrutinize the investigator's report, not act as a rubber stamp, and that they need to remember that the accused has not been able to exercise his right to defense at this early part in the process. In some ways, the work of a review board is like that of a grand jury. Grand juries, like review boards, are supposed to act as shields against arbitrary, unfounded, and malicious accusations of wrongdoing by ensuring that serious accusations are brought only upon the considered judgment of a representative body of fellow citizens acting according to the rule of law. Grand juries, like review boards, don't decide whether the accused is guilty. They merely decide whether there is probable cause to believe that a crime occurred and probable cause to believe that the person accused committed that crime. In short, grand juries, like review boards, decide only whether there's enough evidence to proceed to the next stage in the judicial process. And this is because of the deliberately one-sided nature of grand jury proceedings. Only the prosecutor, not the defense, gets to address a grand jury. All of the important safeguards of justice are saved for the real trial that comes only after the grand jury has performed its important task. Nevertheless, the life and reputation of a fellow citizen is often in the hands of grand jurors and you as review board members. Indictments, like recommendations from review boards, often receive press coverage in which these legal niceties are overlooked, meaning that the reputation of the person accused is harmed and his life thrown into turmoil. This is why it's critical that review board members carefully scrutinize the information presented by the investigator. So an analogy might be helpful here. Let's assume that Joe the juror is called to be impaneled in a case involving Mary, who has been accused of a crime. On the first day of the trial, Joe is expecting to hear the witnesses and to see the evidence regarding the alleged crimes of Mary. Joe's surprised, though, to learn that Mary's legal team hasn't been invited to the trial. So Mary's lawyers won't be presenting a defense, they won't be calling any witnesses, and they won't be making a single argument on Mary's behalf. Now, this is not likely to happen in an American courtroom, one hopes, but the point here is to show the real nature of a canonical preliminary investigation. What would we conclude about Joe the juror if at the end of the trial, and despite the fact that Mary wasn't allowed to exercise her natural human right to self-defense throughout, that Joe somehow nevertheless arrives at a verdict of guilt beyond a reasonable doubt? And would our opinion of Joe change if he were impaneled on a jury hearing just civil claims against Mary, where the standard of proof is lower than beyond a reasonable doubt? We see how impossible it is for Joe to really determine what happened and whether Mary is guilty or liable, according to any decent standard of proof. Now, maybe if he were asked to be part of a grand jury, tasked with deciding whether there was enough probable cause for Mary to be arrested, but to declare her guilty and deprive her of her job and reputation and life and liberty, hardly. Keep in mind, too, that the accused has a right not to speak, has been pointed out before. Be careful, too, of Canon 983 and Canon 220. Well, Canon 983 protects the seal of the confessional, and Canon 220 protects, again, the English translation is privacy, but it means your internal forum, your interiority. So it's very sacred. And sadly, I've been at review board meetings where questions from, I'm sure they were well-intentioned, or the investigators have asked questions that have violated one or the other of these things. Now, you might hear, well, why would anyone make a false claim? Well, it's not the responsibility of the review board, much less the accused, although they are often asked this, to determine why a particular accuser is coming forward. As was noted earlier, there may be many reasons why an accusation might be false, including everything from mistaken identity to jealousy to ulterior motives, such as attention-seeking or financial gain. As early as the book of Genesis, we see Potiphar's wife falsely accusing Joseph, and then there's the story in Daniel involving the corrupt judges in Susanna. Sad to say, these kinds of things aren't just Bible stories. At one review board meeting, which I attended, sitting alongside the accused priest, the very understandable sentiment was expressed this way. Listen, there's someone out there in the church right now who is harmed by the misconduct of this Catholic priest. We as a board have to do something about that. Well, it's not just because I was the priest's advocate that I needed to remind the person that no matter how tempting that feeling may be, that's not the job of a review board. And it would actually be wrong, an injustice, and quite possibly a sin, to misuse a canonical legal institution such as a review board for purposes outside the law and for purposes for which it wasn't intended. Helping one victim by creating others is not a path toward justice and healing. And keep in mind the semblance of truth standard. Do's and don'ts. First, we don't engage in decision-making by default. In other words, some might be inclined, given what I just said, to err on the side of caution by routinely ruling against clerics, thinking, well, they'll get their day in canonical court eventually, so what's the big deal? That would be a gross dereliction of duty and could inflict serious damage on individual priests and the ecclesial community in general. Especially in the current environment, our review board determination that an individual has been credibly accused often has enormous, immediate, and lasting consequences for the accused cleric, even if he should later be proven innocent. Thus, these decisions require careful deliberation, not automatic processing. Do respect the presumption of innocence. As it's been pointed out earlier, you have to begin with a presumption in his favor. Now, that might be difficult to do, but it's your duty. Given that the review board is a canonical institution, it's only right that any language used by it is canonically accurate. As a result, popular phrases such as credibly accused should be avoided. The semblance of truth should be used instead. As Sean Cardinal O'Malley of Boston has pointed out on the website of his diocese, the term credible can have a variety of meanings, and so it's not helpful. He doesn't use it. The common term substantiated is also inherently problematic. Not only is a review board decision merely advisory, but by its very nature, it's been reached without the accused ever having had an opportunity to defend himself. Think of our Joe the Juror example. And the phrase established allegation is an oxymoron. Allegation signifies only an as yet unproven statement or accusation. The adjective established, on the other hand, means something demonstrated or proven as stable. It's a bit like saying, well, it's a proven claim that's not yet proven. So it's better to stick to the canonical language, which everyone has to remember is Latin, saltum veri similem, and not just some translation. Also, if you lack information as a viewer and member to make a recommendation, you don't have to. You can ask for more time. You can seek more counsel from the promoter of justice or from another, or even go right to the bishop with your concerns. You have that right. Now, ordinaries are free to disagree with the review board's decision, but as it's been pointed out before, it's not usual for this to happen in the current environment. If the case involves an allegation of child sexual abuse and has a semblance of truth, the process goes forward. The case goes to Rome, where it's considered by the Dicastery for the Doctrine of the Faith, the DDF, the entity charged with investigating the most serious crimes against faith and morals. And because of the current workload there, it might be several months to more than a year before the cleric would be able to have his case heard, either in Rome or back at the local diocesan level, depending on what the DDF suggests after they've completed their initial review of the case. Now, one way of proceeding is with a canonical judicial trial, in which there are dozens of pertinent canons contained in Book 7 of the 83 Code, along with a panel of judges, lawyers on both sides, documents being submitted and evaluated. Witnesses may be brought in for questioning, but unlike in, courtroom drama movies, there's little, if any, live questioning of witnesses. When there is questioning, the judges do it, not the lawyers. And this is all consistent with the inquisitorial system that's employed in canon law and in many European civil systems as well. The other way of proceeding, the way which is much more common, at least at present in the United States, is the administrative or extrajudicial route, in which the bishop himself plays a more central role in the determination of the case. Fewer specific rules are described in the code for this route, but any judgment must still be made according to the same demanding standard of moral certainty. One final comment. Last fall, a study was published on priests in the US. As the Wall Street Journal reported, 20 years after the introduction of the Dallas Charter, the relationship between priests and bishops is hurting. The findings show that 82% of priests regularly fear being falsely accused of sexual abuse, and only a third of the respondents believe their diocese will help them defend their rights in the event of an accusation. This crisis of trust certainly affects their ability to bring the gospel to a culture sorely in need of it. So kudos to you all on this webinar for considering ways and for working hard so we can improve the current situation. This same survey pointed out how public ministry is life-giving to priests, and therefore suffering through an interminable period of administrative leave or constantly living under a cloud of suspicion is detrimental to their physical, emotional, and spiritual health. Review board members should be very careful before recommending that a priest be kept out of ministry, especially for a long time, and when it can inflict serious and lasting damage to the priest's reputation. And with that, I'll turn it over to Paul Chadwick.
Thanks, Michael, for a terrific presentation once again. That concludes the presentation pieces that we have prepared for today, but we do have a fair amount of questions. And we'll go ahead and I'm going to go throw some of these out here. We'll try to get through all of them if we can. And so I know we kind of overstayed our time, but I think everybody would agree that this is we can't be accused of not being content rich. There's a lot of information here. We'll go ahead and start with the questions, and then any one of the panelists can feel free to grab these. I'm going to go ahead and I pulled a couple of them here. One of them is, this is a good question, and I'm not revealing who's asking what questions. We're keeping these all kind of anonymous for now. My question is this: is there any hope of the USCCB working with MOM to develop consistent standards in the US and some level of USCCB enforcement or at least oversight. So I'll go ahead and throw that out to whoever wants to take that on the panel.
Joe Maher, I think you're muted.
Glad I am. Is there any hope of the USCCB working with MOM to develop consistent standards in the US and some level of USCCB enforcement or at least oversight? I would hope that members of the USCCB are watching this webinar. All of them got the MOM model policy. All of them received the handbook. The independent review board orientation handbook that we sent out. We have several bishops that support our work that we talk to. And I would say yes, that the USCCB is interested in working with whoever can help them with these kind of situations. But again, it's USCCB that would reach out to us because obviously we're providing them with whatever they need. So it's not a direct answer to your question. We would certainly be open to working with the USCCB if they needed our support. But more to the point, the ordinary, as Michael has said, and Dave also in his presentation, the ordinary is a decision maker, right? I mean, the ordinary is as we say, the leader of his diocese. He's the one that's going to make the decision on these cases and that. So everything that we do is geared towards all the individual ordinaries in the United States and around the world. We send it obviously to the Apostolic Nuncio, and the Vatican is aware of our efforts. So we hope that what we're able to provide will help them and help them in the determination of these cases and in their own processes.
Great, thanks, Joe. We have another question. Generally speaking, what is the burden of proof for these boards? And what should the burden of proof be?
I just answered that in the side column.
Okay.
Easy answer, I think. It's supposed to be semblance of truth, but as you see, it's all over the place with other standards instead.
And there was a follow-up to that, Dave. I don't know if you saw that. It says, but at the review board, what evidence needs to be there? I'm assuming it's not just simply Jane accused Father Smith of doing X, and that's it. No evidence, no collaborating evidence, etc. If it's just the accuser, isn't it a case of he said, she said?
Throw a shot.
Yeah, it really comes down to the quantum of proof that you are looking for to meet the standard. And you also have to keep in mind who bears the burden. If we start from a presumption of innocence, then it is the complainant who has the burden of persuading you that there is a semblance of truth there. And as I talked about in my segment, the thought is we need to give some concrete parameters. We need to put some guardrails on what a semblance of truth means. And so I offered the definition of a reasonably cautious person looking to the evidence through that presumption of innocence as to whether it's probable that the alleged act occurred and that it's probable that the priest is the one who performed it. And unless somebody persuades you of that, then the answer would be you haven't met your burden. And it would not be, in my estimation, appropriate to recommend any adverse action against the priest if the threshold that you have set has not been met by the person who has to meet it.
Great. Thank you, Joe. Here's another one. It's true that canon law calls for a very basic investigation and for a canonical trial to be the forum where the facts are determined. When it comes to delecta activity, I'm reluctant to entrust this process to a group of canon lawyers rather than a professional investigator or team of investigators. It seems to me a better practice for an investigator to complete a robust investigation and then hand those findings over to the canonist to apply the law to the facts as set forth by the investigator. Comments on that?
Well, I think that question came in before I gave my remarks, and I hope that I responded to that because we need to remember what the purpose of the preliminary investigation is. And I think the adjective there, preliminary, is very important, giving the goal of it. And this is right out of the vademecum too. The goal is to establish enough stuff to go to the next level of the process or not. It's not a trial. And there are many, many ways for the investigator, especially if it's thorough, to step on the rights of the individual along the process of amassing all this mountain of activity. You know, the other thing that's got to be kept in mind here, I think, is it may be unintentional, but it's a reality. I mean, where are the incentives? I mean, if somebody is told, do an investigation and basically do as thorough a job as you possibly can, well, if they're professional investigators, they could take months to do that. And it could cost thousands and thousands of dollars. And you say, well, where are you going with that exactly? This is, again, under the law, it's supposed to be a preliminary investigation, not the full-blown trial. Because if you arrive at the end of this, what's the point of a trial? The defendant is not going to be presumed innocent anymore, as he should be, but he's going to have to be digging out of this massive hole. Anyway, we could go on, but I hope that question was already answered in my presentation.
And my thought on that, just briefly, comes more from the secular courts perspective than it does, since I'm not a canonist. But the question also triggered for me a question in my mind of who is the fact finder. And as we heard earlier, right, there are judges in our canonical system who should be making those factual determinations. Yes, the investigator gathers the evidence, but I think the question assumes that whatever facts the investigator finds are the facts, that they're incontrovertible. And so you simply apply the law to those facts. And I would suggest at the investigation stage, if you analogized it to civil courts, whether it be a civil litigation or a criminal matter, police officers don't have any special presumptions that attach to the testimony that they bring into court. The government is still put to its paces with whatever evidence the investigator has collected when it's presented in court. And it's either the jury or, in a bench trial, the judge that makes the ultimate factual findings. So in that regard, I think the question kind of presupposes putting a lot of power in the hands of the investigator that I don't think, from what I heard today, is really contemplated under canon law, and certainly would not be the case under civil law.
Yeah. Thank you, Joe. This is one for Joe Maher. How can we obtain a copy of the IRB handbook? Unmute, Joe.
Unmute again, Joe.
Okay.
Wasn't I the one before this whole started to make sure that you unmute when you you can email me, Joe Maher at menandmelchizedek.org, or call 800-674-9693, or go to our website. It's there in PDF form, but you can click an email there, and we'd be happy to send a copy to you. We have plenty of them available, hard copies of the handbook. And if you're a review board member, or if you're a bishop or member of the chancery or diocese and would like several copies for your review board or your vicars, that'd be fine too. Just let us know. We'd be happy to send them to you.
Awesome. Great. Thanks, Joe. Here's another question. Some bishops, archbishops, are requiring accused priests to submit to the ABEL, sex offenders assessment, to prove they're innocent in order to return to ministry. What are your thoughts on this? Who wants to grab that one?
Well, I have many thoughts. One is this is where I think it comes in handy to have good canonical counsel. and this is not a commercial, but it's a fact that a priest should be able to have access to someone who can help him assert his rights, because the able assessment is problematic, and let alone this whole notion, that you have to prove your innocence to come back. Now, maybe you have to prove that you're capable, and if the bishop has a legitimate reason for questioning a guy's fitness for ministry, well, there are ways to uncover that. And not only does the bishop have a right to investigate, but the bishop has a duty to investigate, so he doesn't unleash some crazy person onto the faithful. We've already been through that. But the question is the able assessment the right tool? And because it is problematic, and I think there are good alternatives, that priests should avail themselves of somebody who can help them out of that jam, because that's a tough one.
Thank you, Michael. Another question. On what basis do you say that IRBs are limited to the very grave delicts? It goes on to say the charter requires them in the US for allegations of sexual abuse of minors, but it doesn't mention any other grave delicts. There is also nothing in canon law prohibiting a bishop from expanding the scope of his review board.
Right. I think that's what I had said, that a bishop can use a review board for suitability, and the decision, as long as the decision is with the bishop, he can use whatever means he wants, as long as he doesn't violate someone's rights or the law. But the notion that review boards are limited to the grave delict of the sexual abuse of a minor is right in the charter and the essential norms. That's where they were born, but clearly they have expanded their reach in the United States. And again, part of it is the story that we can tell as a result, that, listen, the bishop or the decision maker in a religious order, whatever, is not just relying on an internal echo chamber of clerics, but he's involving the actions, he's involving lay people. And that's seen as, a step in the right direction, at transparency, at thoroughly vetting things. And again, in theory, that's great. It's the practice that we have to be very careful of. And that's why we have this webinar, is that to provide some guidance for the right exercise of this very important power.
Again, thank you, Michael. This is less of a question, more of a statement, I think, looking for a comment. I have been personally involved in a process in which there are many instances of my rights being violated. This has been possible, at least in part, because an individual, diocese/bishop, can do whatever it wants with no regard to any consistent standard. I'm not aware of an instance where Rome has clapped back on a diocese for violation in the areas cited.
Well, I can take a crack at this one because I am aware of places of cases in which Rome has gently invited bishops back to respect the law and the rights of the priest. Again, it's kind of a delicate dance here. You have to think about it from a Catholic perspective, right? Rome is not going to want to run the 200 dioceses and more religious orders in the United States of America. They're not going to second guess every single decision of the bishop. So there's going to be clearly, some deference given, a lot of deference given to the local bishop when he makes a call. But that doesn't mean that he can just do whatever he wants. And of course, in real life here, a lot of times bishops feel like they can, or it's not just the bishops, but it's the diocesan staff or the diocesan lawyers or whatever, and say, what is this priest going to do? He's a risk, he's a liability. We're going to throw him under the bus and beg him to speak up. Well, if you do speak up in the right way, and good things can happen. There's a case that was from 2017 that I talk about all the time, that was just published or not just, but published recently in 2020 in a canonical journal, in which it talked about basically the failure of a bishop to stand up for the rights of his priest, because this priest had been accused falsely. It turned out he'd been cleared both civilly and canonically, but the bishop wouldn't put him back. And he said, you've got all this bad publicity about you. I can't put you back. And the apostolic signatura, the church's highest court for this particular matter, said, essentially, I'm paraphrasing, au contraire. Yeah, you, bishop, have a duty to stand up for your priest and a duty to educate your faithful on the on rumor. And I thought that was very interesting. But having said all that, it's tough. It's a tough environment, and even that case that I told you about, it's not like you can just go on Westlaw or Lexis, and find it. These cases are printed only in Latin, and then they have to get published in a journal into some other language with official translation, and then they're kind of just peppered out here and there, and so you have to know where to look to find some of these cases, and then you can bring those back into a conversation with the bishop and say, Bishop, just wanting to let you know that this is word from Rome about some alternatives to the current situation. So think about that.
Another question here. How do you suggest a bishop go about choosing members for an IRB? What should the process be?
I have one quick thought on that. And we've actually given some collective thought to that and putting together criteria for serving on an IRB. But as I mentioned in my presentation, pretty much every civil case, every civil commercial case you'll be involved in will have experts, and they always line up against each other. They're always opposite. There's a very nice word that I could use for them that I probably not for public consumption, but let's just say they belong to the oldest profession in the world. And if you pay them, they'll say whatever you want. So I have a very deep inherent skepticism against anybody who is called an expert, because they are beholden to somebody. They're paid by somebody. So I am going to take that healthy sense of skepticism and impose it on the context of an IRB. And therefore, I think this should happen. I think you should have opposing experts involved. If you just line it up with former FBI officials and former cops, you're going to get exactly what you expect, the decisions that lean in favor of law enforcement. I'm sorry, but that's just the way things work. So I'm not opposed to having FBI agents and former detectives, sit on IRBs, but you need to have public defenders and other people on the opposite side to sit on it too, to balance them out. Iron sharpens iron. I get that. I'm not saying these people are not of goodwill. I'm not saying that. What I am saying, though, is that they have biases and prejudices that are built into them that will come out in time, and that they need to be balanced with others. So I don't think, it suits to just say, hey, I've got my IRB stacked up with a bunch of great experts if they're all stacked on one side. I think you need to you balance it with both and let them go at each other in a nice, civil, Christian, charitable way.
Great. Thank you, David. Here's another one. Putting a person on administrative leave while under investigation is a routine matter in other professions, such as law enforcement. Why can't this be the case for priests? It's not the case that stepping out of ministry during a routine investigation is necessarily going to ruin a man's life or reputation. The more normal this is, the easier it is to return a man to ministry following an investigation. We've successfully done this in our diocese. Open investigation, remove the man from ministry as a matter of course, and do this in all cases. Make it clear in any announcement that this is routine, innocence is presumed, etc. Then equally publicize when he is returned to ministry that he has been cleared. This is a legitimate way to proceed. Okay, again, not a question, but some commentary. Anybody have any thoughts on this? Would like to comment on this as well?
I like to see every diocese in the United States do exactly what they're talking about. That if you're going to remove a priest from ministry, that you're going to make it absolutely clear that the priest himself has volunteered to step away while there is a preliminary investigation. And that when he is cleared, if he is cleared, and we're assuming, in this case, that when he is cleared, that the ordinary himself makes a public statement that says, not only is he cleared, but it is my responsibility also to restore his good name, and that he is put right back into the position he was before. So if a pastor of a parish is accused of abuse and he voluntarily steps away in the press release saying that he voluntarily agrees to step away while the preliminary investigation is going on, and he is cleared, he is put right back into the pastorship of where he was before, and that the bishop makes a statement. And there are bishops that have done that in the United States, and they're right. The comment's right. It has worked, but you have to be very careful, because as soon as something's publicized, it doesn't matter how 12 ways to Sunday that you say that he's been cleared. As many priests have said, where do I go to get my reputation back? Once it's made public. So it's never going to be fully restored, but it's the best case scenario. And I would hope that other bishops would follow that. And because I think that there are a lot of priests that are cleared, that are not put back into ministry, they're put back in so-called limited ministry, and eventually they're either retired out with full faculties or with limited faculties, and that's just not fair, and that's not right.
Great, thank you, Joe.
So I have a couple of thoughts on that, Paul, and it's really kind of tying together a couple of questions that were raised earlier, along with the discussion in response to them. So we talked, for example, about how IRB's remit is being expanded to cover things beyond just grave delicts, which, if you analogize it to the law enforcement context, as the person asking the question did, there are all kinds of complaints that get asserted against police officers, and those are handled through internal affairs reviews. Depending on the level of the accusation, whatever the complaint may be, it may simply be that the officer continues without having been removed from his patrol. It may be that he is put on desk duty for a period of time, so he is still on the job. He is still performing the functions of a police officer. He's just not performing the same functions that were under review. And then, of course, if there are very serious accusations, or if you have an officer who's involved in a shooting, they may, in fact, be taken completely out of duty pending a completion of a review. Every police department is going to have a different policy on each of these different levels and how the officer will be treated. But a one-size-fits-all approach is not taken in the law enforcement context. And so if you're going to have IRBs reviewing lesser complaints, the question in my mind is really, are those complaints that they're fielding appropriate to have a priest removed? That's a judgment call that bishops are going to have to make, but not every complaint requires removing a priest. At the same time, there's a lot more procedural protections that are built in for law enforcement officers through those internal affairs programs. They have a right to representation. They are essentially given a mini trial. It's not, I know Michael had used the term extrajudicial. So in that sense, it's more of an agency administrative review, but it looks and feels a lot like a trial in many instances. And a lot of those protections that we've been talking about are available to those officers. It doesn't strike me that that's what we're doing with priests who are accused. So again, I would caution against a one-size-fits-all approach and really tailor it to the specific kind of complaints that you're facing as they come in.
Thanks, Joe. We only have a couple more questions, and but this is one that was asked a while ago. If a review board determines that an accusation is credible and has a semblance of truth, and the priest is removed from ministry, and subsequent to that, he is found innocent, what recourse does the priest have against the board?
None. I'm just going to be blunt about it. You can't sue the church internally. Most courts, I mean, maybe there are some courts somewhere who do that, but in the major jurisdictions I've seen, the civil courts will not get involved in disputes intra-church. They just don't. And you know what? We should celebrate that. I don't think we really want to have civil courts, you know, poking their noses around church decisions, second guessing them. But that leaves a tragedy because an injustice has occurred. It also raises a heightened duty, I think, on the part of church to make sure that it gets it right, so that one isn't hurt because they have no practical means of civil recourse. And by the way, there were two questions that were related to this. One is, can you sue the IRB? Very doubtful. Maybe somewhere, some weird state that lets you do it. I'm not aware of one. But second issue somebody raised is, can you sue the accusers? Well, you could in theory, but let me talk to you about all the ways involved in doing it, including expense and uncertainty and backfire potential. And you know, another very deadly legal issue that exists here in California and in a lot of other jurisdictions, which is called an anti-SLAPP law. And it's basically says that if somebody files suit against somebody else for having, you know, taken some action of, quote, public interest, then they get to dismiss the suit and collect attorney's fees out of it. So, you know, I've had to have very sober conversations with priests about, you know, what they could do about, you know, suing others for it and explaining, well, you could, but just bear in mind, you're going to get the force of a lion coming back at you. And, you know, you either be really poor or really rich to want to deal with it.
Great comment.
What Dave said, I think is totally true from a civil perspective. I think canonically there are some other options, but it's very fact specific. But you know, there is a functioning legal system within the Catholic Church, and there is recourse for defamation, recovery for damages. But in terms of just like an ordinary review board coming out the way that you don't like, probably not. But if you know, there's active defamation against somebody, that's possible. But of course, that's only within the canonical sphere. So it's a very specific analysis and set of options.
Yeah, and it's also one that really ties into all three areas that we're talking about. For Michael on the canonical side, for Dave on the civil side, for me on the criminal side. Statutes of limitations on the criminal side are much longer than defamation. It's an issue I don't think that legislatures have really given any thought to, as they have expanded the statute of limitations for claims against folks who, or excuse me, claims by folks who claim abuse many years ago. I think there is a natural and fair belief that those folks should get their day in court. But we also know that there are false accusations. And so if those false accusations are made hoping to capitalize on the generous extension of the statute of limitations for those appropriate cases, there ought to be a coordinate extension of any limitations period for defamation claims, but there aren't right now. So at least in most states, you're looking at a limitations period that will run somewhere between 6 months to 2 years. There may be one or two states out there with a slightly longer period of time, but criminal limitations periods last, you know, minimum 5-6 years and can last far longer. In fact, for some crimes, there are no statutes of limitation. So in that sense, if you go off and fire a civil complaint, there may be some information that gets developed, and that I think is the backfiring that Dave was talking about earlier, where the evidence that comes out may ultimately support a criminal charge, whereas before, without the benefit of that civil discovery, no criminal action would have been brought. So there's a lot of competing concerns there. And it's really important that if you're in that situation, you're contemplating it, to really get advice from all three kind of areas of expertise: canonical, civil, and criminal.
Great input, Joe. I think Dave is actually answering this question kind of in real time, but I'll ask it out loud here. This just came in. How is an investigation to take place in the preliminary process yielding information for the IRB when the insurance company advises against, since the content is discoverable?
So I'm sure everybody wants to hang on for another couple hours while we answer that question. It is a hugely important question. I'd love to talk about it, but I'd love to talk about it, but we don't have the time. Call me, send me an email. I'll be happy to talk through it, but it's enormously important and very difficult.
Great. And also, I think the last question we haven't addressed yet, and I'm going to pull this up here right now, is I think this ties to one of Dave's closing slides on prayer. And this individual asked, he goes, bishops are not infallible. How is it that a priest's life can be determined by someone who is capable of mistakes and boards that are not trained in the way suggested today? Where is Jesus in this?
Jesus isn't always in this. And that's when we first started this webinar. I mean, there's an old saying, right, that people used to have these stickers, what would Jesus do? You know, and that's what the whole purpose of these fine gentlemen are here and spending so much time on this is about. Because unfortunately, there are factors that cause people to react certain ways that are not necessarily the ways of the church or ways of Christianity. I've had conversations with bishops and priests and vicars and others, sometimes that really struggle, because they're worried about the press, they're worried about liability, they're worried, well, what if I put this guy back out there and then if something happens, or I always have to come back and say, we're Christians, we have to do what Christ would do. We have to remember that above everything else. So sometimes Jesus isn't in it. Sometimes it's, as they pointed out here, it's the liability issues. It's the press. It's the image. It's absolute fear. And this is where independent review boards can be very, very good for the church, because they can look at things and evaluate the information and say, what are the facts here? And look, the litmus test for all of us is, can we look Jesus in the eyes and say what we did was the right thing to do?
I'm glad we're winding up here on a spiritual note, because I think that's the best way forward here. And I would say, in answer to that question, of mirroring Joe, I think Jesus is in this at the side of the falsely accused priest, and he is helping that falsely accused priest go through this. I think he's at the side of the priest who made a misstep and who made a mistake and wants to come back in ministry. And it's not a fatal mistake, it's a misstep. And we believe in the confessional for priests, as we do with lay people. And the hard thing is having everybody see that. And I would say, just like Jesus is at the side of all those people who really did suffer sexual abuse at the hands of men that they trusted, that is a horrible suffering as well. So Jesus is near the suffering. He's always with them and us, and we can't ever forget that. And so I think, one thing that this webinar hopes to do, and Mena Melchizedek in general, is just to stand as a little beacon of hope that, yeah, this is a tough time in the church right now, but we're going to get through it, but we're going to get through it together. And prayer is fundamental to that.
Thank you, Michael. Well, I think that pretty much wraps it up for now. I think we've exhausted the questions. First of all, amazingly, we are an hour over time, and we thought that we would be, because there's so much content. And what I find amazing is, I think from beginning to end, we've only had 7 people drop off, and they didn't drop off until after the first hour. So very thanks to all of you who stuck with us to the end through the Q&A session. As we always do, we open and close with prayer. So we're going to close right now with a prayer. We're going to say the Memorare to Our Lady. So please join with me. In the name of the Father, and the Son, and the Holy Spirit. Amen. O most gracious Virgin Mary, that never was it known that anyone who fled to thy protection, implored thy help, or sought thy intercession was left unaided. Inspired by this confidence, I fly into thee, O Virgin, my mother. To thee I come, before you I stand, sinful and sorrowful. O Mother of the Word incarnate, despise not my petitions, but in thy mercy hear and answer me. Amen. God bless our priests. In the name of the Father, and the Son, and the Holy Spirit. Amen. Thank you all for joining us, and we would love to hear from you. So send emails. Would love to hear comments on whether you find this helpful or not. Let us know. Thanks so much. God bless everybody.